So how to get a high grade in criminal law? Well, the first thing to do is you need to revise the most important topics in criminal law. The most important topics that usually come up in criminal law assessments is property offences, offences against the person, murder, voluntary manslaughter, involuntary manslaughter, so all the homicide offences. Also, the sexual offences often come up as a problem question, could be an essay question as well. I suggest you have a look at your past exam papers to see all kinds of questions that you may receive on these topics, and then practice answering problem and essay questions that may come up. Today's topic will be sexual offences, and we will revise the main provisions from Sexual Offences Act, as well as some cases. So, actus reus and mens rea of the main offences from Sexual Offences Act 2003, and the consent element. And finally, I'll advise you how you should approach a problem question on sexual offences. Section 1 of the Sexual Offences Act 2003 is rape, which is the highest, the most serious offence. In a problem question, you can start from the most serious offence and then go to the lesser offences. So the same approach applies to homicide offences. You can start from murder, and then you can see if there are any defences that could convert the liability to manslaughter instead, and then if there are full defences or partial defences and so on. So we start from the discussion of the most serious offence under the Sexual Offences Act, which is Section 1, rape. The three main elements of this offence is intentional penetration, lack of consent, and lack of belief in consent. Usually, the penetration part is easy to see on the facts of the question, and what causes most controversy and where students lose marks is in the discussion of consent, because it's sometimes quite hard to understand if there was consent or at least a belief in consent. So make sure that you understand how you should apply the law correctly to provide appropriate analysis for consent element. The circumstance element, B does not consent, question of B's subjective state of mind. It is a question of fact for the jury to decide based on victim's subjective state of mind. So it's at the end of the day, the jury that decides whether or not there was consent. But what you need to do is not to give a definite answer, because that's impossible, but you have to give analysis and all possible scenarios, like on what basis could you argue that there was consent, and on what basis you could argue that there was no consent. Well, the best way to go for it is if you provide examples. We always use case law to support our arguments. First of all, well, you need to go through the Sexual Offences Act, which is the relevant statute, and then you need to have a look at the relevant cases and make sure that you apply the relevant case law. And if you can find a case where in a similar situation, consent was not found, most likely you can argue that according to this case, it is unlikely that the consent will be found because this case was similar to this one that is given to you, and therefore it should be applied. You should take into consideration that marital rape is recognized in the UK in 1991. The case that recognized marital rape is RVR, where a wife was successful to convict her husband in rape. And the mens rea for rape is intentional penetration when the defendant does not reasonably believe in victim's consent, which is an objective test, having regard to the circumstances and the steps that defendant has taken to ascertain whether or not victim consents. And the jury may take into account defendant's age, sexual experience, learning difficulties, and so on. So the circumstances element means that everything, all the background circumstances will be taken into consideration to understand whether or not there was a genuine consent, or at least a belief in consent. We have definitions of consent. You can have a look at section 75, 76, and 74, which are the guidelines for this element of consent. 75 is evidentiary presumptions of non-consent, which means that if any of the scenarios apply from section 75, that's a presumption that there was no consent. And section 74 is a general definition of consent. So if you cannot identify, if none of the evidentiary presumptions of non-consent applies to the facts of the case that has been given to you on the problem question scenario, you should apply the general definition of section 74, which defines consent as a person consents if he agrees by choice, has the freedom and capacity to make that choice. So first, you need to cite this, section 74, that states the definition that I just read, and then discuss whether or not in the problem question scenario that you have in front of you, it is evident that a person consented by choice, had the freedom and capacity to make that choice. Capacity is usually, they refer to at these cases where the victim was very, very drunk, and whether or not the person had the capacity, was like conscient enough to make that choice. Section 76, if in the proceedings for an offence to which this section applies, it is provided that the defendant did the relevant act and any of the circumstances specified in subsection 2 existed, it is conclusively presumed that the complainant did not consent to the relevant act, and the defendant did not believe that the complainant consented to the relevant act. So what are these presumptions, right? This is section 75. Here are the 6 presumptions. Any person was at the time of the relevant act or immediately before it began using violence against the complainant or causing the complainant to fear that immediate violence would be used against them. So if the violence is involved, if the complainant feared that the defendant would become violent, and that was the reason for consent. Also, if any person was at the time of the relevant act or immediately before it began, causing the complainant to fear that the violence was being used or that immediate violence would be used against another. So not just against the victim, but even if the violence is directed towards another person, a third person, that would also count. The complainant was and the defendant was not unlawfully detained at the time of the relevant act. Unlawful detention, so if the person is locked up in a place. And also the 4th scenario is the complainant was asleep or otherwise unconscious. Due to the complainant's physical disability, the complainant would not have been able to, at the time of the relevant act, to communicate to the defendant whether the complainant consented. Again, this refers to the capacity of the person consenting. So whether or not the person had the capacity to understand the nature of the act and make an informed choice. And finally, any person had administered to or caused to be taken by the complainant without the complainant's consent a substance which, having regard to when it was administered or taken, was capable of causing or enabling the complainant to be stupefied or overpowered at the time of the relevant act. Stupefied, overpowered, that refers to drugs and alcohol mainly. You should take into consideration that drunken consent is still consent. However, as this provision says, if alcohol or drugs was taken without the complainant's consent, in that case, it's not considered as consent. So if the complainant voluntarily took alcohol and got drunk, that's another issue than if the person gave alcohol without the complainant's knowledge or a drug. Section 74, as we discussed, is a general definition of consent. An individual consents if they agree by choice and has the freedom and capacity to make that choice. By choice is a clear indication that the consent should be seen as a positive sign of willingness. The case about this that I'd like to draw your attention is Gita. Here, defendant sent several anonymous text messages over several years purporting to be from the police to the victim. The defendant told victim to continue to have a relationship with the defendant to avoid fines for causing distress. And they also had sexual intercourse. And the court charged defendant with rape under Sexual Offences Act because defendant deception undermines victim's apparent consent. So there was no freedom and capacity to make the consent. There was deception, so the defendant threatened basically to the victim that they would get fines and that he was from police. Other provisions from Sexual Offences Act 2003 that may come up in your exam on criminal law is Section 2, which is sexual offense by assault by penetration. Section 3 is sexual assault. Section 4 is causing a person to engage in sexual activity without consent. And then from Section 5 to 15, those are sexual offenses against children, which is another thing. So you need to take into consideration that if the victim in the problem question scenario is a child, you do not apply any of these sections from 1 to 4. You should have a look at the section 5 onwards. So how do you approach a problem question on sexual offenses? First thing is to identify which of the Sexual Offences Act 2003 is the most relevant to the problem question. Is it the Section 1, which is rape, or if it's a child, that you have to have a look at this Section 5 onwards. So make sure you identify the most relevant one. Then, as in every offense in criminal law, you need to say what is the actus reus and mens rea of the relevant offense. And then after stating what is the actus reus and mens rea, you need to apply it to the facts of the case and say to what extent the actus reus and mens rea is present. In the mens rea part, you need to discuss also consent, which is the most important for this topic. And you need to start from Section 76 and 75, say whether or not any of the presumptions apply. If any of the presumptions apply, most likely you should conclude that there was no consent. If the presumptions does not apply, then you should have a look at the general definition of consent under Section 74 and discuss to what extent the victim made a free and informed choice and was capable to make that choice. So make sure that you provide detailed analysis. However, sometimes it is hard to understand whether or not it was the consent was made, it was a free choice and the victim was capable and free to make that choice. So make sure that you use the relevant case law. Without the relevant case law, your Section 74 analysis will be incomplete and you will not get a high grade. So make sure that you read the case law under Section 74. If you go to our notes, you will see relevant case law for all the sections, Section 76, 75, 74. You will see the case law there. So you will be able to apply the relevant cases to your problem question scenario. I suggest that you have a look at our notes for that. Good news is that we have an example essay. It's a problem question on sexual offences. It was awarded 68, so it's a high 2-1 level example answer. And I suggest the best way to go to practice with it is if you read the question, try to answer it yourself, draft an answer, and then compare your answer to the answer that we have. That way you will be able to practice and save some money to not get a tutoring session. But I do suggest to get a tutoring session, at least a couple of tutoring sessions before your assessment. But obviously it is suggested that you practice as much as possible. So you should use our example essays to practice, plus at least a couple of hours of tutoring would be the best for you to maximize your chances of getting a first class. Also, you should have a look at this model essay, other model essays we have in criminal law, and make sure that you practice with them as well. We have all the 6 types of content. For criminal law, we have revision notes, cases, essay examples, quiz, tutorial videos, and flashcards. So make sure that you subscribe as soon as possible and start practicing. So how can we help you? As you already saw, we have simple study resources focusing on getting high grades, and you should use them to maximize your chances of getting high grades. If the resources are not enough, you should have a look at our tutoring services. The tutor will be able to guide you, give you tailored and personalized support exactly about what you're struggling with, and will answer all your questions and doubts. We have already helped thousands of law students get high grades. If you want to be the next student to get a first-class law degree, you should join SimpleStudying now. Thank you for your attention.